Someone keeps encouraging me to like beat you up in Minecraft. I don't know why. They really want to see me beat you up. They're like, literally, punch her, do it. You know you want to feel the rage flow within you and strike, little penguin. They're like super.
3 hearts. Ah! 2 hearts.
On the 24th of June 2022, Petra Gurin and Elira Pendora were playing Minecraft to an audience of thousands. Petra's chat egged her on to bash Elira Pendora, to which Elira told Petra she should
Do it, coward!
Petra agreed, and immediately after, Petra found Elira and punched her. The fight was initially on 2 fronts, but eventually turned into a one-sided fight for Petra to vent her sadistic tendencies towards Elira. As Petra punched Elira, she asked,
Will you die?
to which Elira said.
You punch me, yeah?
Petra then asked Elira to tell her when.
Tell me when you're on your last heart. I don't want to kill you.
Elira agreed and said.
Okay.
Petra would then punch Elira in sets of 2, stop, and then wait for Elira to tell her how many hearts she had left.
3 hearts.
In Minecraft, 1 punch does half a heart of damage. However,
2 hearts.
Elira lied to Petra from the start, claiming she had 5 hearts when she really only had 4. She consistently claimed she had 1 heart more than she actually had, and these misrepresentations would eventually lead Petra to accidentally kill Elira, despite their agreement that Petra would only bring Elira to the brink of death. In this video, I want to determine whether Petra is guilty for Elira's death under New South Wales law. I have 2 disclaimers before I start. The first is that this video is not legal advice and is for general, informational and entertainment purposes only, so please just take the information presented here with a grain of salt. The second is a content warning that this video contains case law discussing sexual violence. Under New South Wales law, there are 2 main offences Petra can be charged with in relation to Elira's death: manslaughter and assault causing death. Manslaughter is a common law offence covering any unlawful killing considered less culpable than murder. In New South Wales, this is codified in section 18(1)b in the Crimes Act 1900. Now, in the case of murder, it wouldn't be a charge here because the prosecution would struggle to pin any of the fault elements onto Petra. So in this case, the law we need to apply is that of involuntary manslaughter. But before we get to that, I want to look at the question of voluntary manslaughter and provocation. I saw a comment in a clip by Gurin Observation Archive thinking that this case might be manslaughter because Petra was provoked by chat. Now, voluntary manslaughter is when a person satisfies all the elements of murder, but a special circumstance causes the defendant to be not guilty of murder, but guilty of the lesser charge of manslaughter. Provocation is a partial defense, where the defendant would argue that they lost self-control due to being provoked and thus should be convicted of manslaughter rather than murder. In New South Wales, provocation is known as extreme provocation and is modified in section 23 of the Crimes Act. You can see very quickly that this cannot be used in the current case because it wasn't the deceased's conduct that was provocative, but chat's, and even then, chat's messages cannot amount to a serious indictable offence, so no provocation. But again, voluntary manslaughter wouldn't be an issue here because that can only arise if murder is an issue to begin with. With that out of the way, let's look at the big issue, that of involuntary manslaughter. Involuntary manslaughter occurs when a person kills another but doesn't have the fault element or the intent necessary. The case of Wilson and the Queen lays out 2 types of involuntary manslaughter: unlawful and dangerous act manslaughter, and manslaughter by criminal negligence. The relevant rules to look at here are those of unlawful and dangerous act manslaughter. The elements are as follows, and the Crown must prove each beyond a reasonable doubt. Now, Petra definitely intended to punch Elira, no issues there, but were her acts dangerous? To determine whether an act is dangerous, the jury must assess the facts using an objective test, where they ask if a reasonable person in the circumstances of the accused would have realized their act was dangerous at the time it was committed. This is straightforward. Having Petra punch Elira close to death, even though she consented, can be considered dangerous by any reasonable person. Now we get to the two big questions. Is Petra's act considered unlawful, and did Petra's act cause the death of Elira? On the surface, the answer seems obvious. Petra's punch killed Elira, and the punch is an unlawful assault, right? Well, this part of the video was extremely difficult to find an answer for because this set of facts is quite unique, and in Australia, there aren't many binding precedents to look to. This is the part of the video where I need to remind everyone that I'm not a lawyer, so take everything with an ocean of salt. First, let's look at the element of unlawfulness. For an act to be considered unlawful under Unlawful and Dangerous Act manslaughter, the act must be a breach of the criminal law, and the Crown must prove the elements of the alleged breach beyond a reasonable doubt. Here, the alleged unlawful act is assault, which occurs when the intentional or reckless application of force is done without the victim's consent. The main issue here is consent. Generally, common assault, which consists of threats of force or light touching, will be negated if consent is present. However, the law will not always accept consent as a defense in certain circumstances. What Petra would like to do is prove that her acts are protected under consent, and therefore the element of unlawfulness cannot be satisfied. The seminal case on this point of law comes from the controversial UK House of Lords decision, R and Brown, where the convictions of gay men engaging in consensual yet extreme sexual acts of sadomasochism were upheld. These acts were The question asked of the court was, where A wounds B occasioning actual bodily harm in the course of a sadomasochistic encounter, does the prosecution have to prove a lack of consent on the part of B before they can establish A's guilt? The court answered no, because consent is not an available defense to actions designed to inflict serious injury for its own sake. As such, if actual or grievous bodily harm is occasioned, consent is not a defense unless the action falls under one of the exceptions, such as tattooing, surgery, boxing, and contact sports, which can be lawful. Finally, Lord Templeman wrote two quotes in Obiter that are relevant to our case. First, a person who assists another to commit suicide is guilty of murder or manslaughter, and second, dueling and fighting are both unlawful, and the consent of the protagonists affords no defense to charges. Brown is quite strict, but in R and Wilson, the effect was slightly mitigated, as the Court of Appeal said Brown is not authority for the proposition that consent is no defense in all circumstances where actual bodily harm is deliberately inflicted. As a result, the Court of Appeal held that a husband consensually branding his initials on his wife's ass was protected by consent. But what if a person consents to an activity that causes grievous bodily harm and then dies? The rules in Brown would say the activity is most likely unlawful, but in New Zealand, Brown was rejected. In the case of R and Lee, the court held that consent could be given to the intentional infliction of harm short of death, and would only intervene if there were good policy reasons to forbid it. This case is probably the most similar to our facts here. It's important to note that these three cases are from overseas jurisdictions and aren't binding on the courts of New South Wales, Australia. These cases haven't been considered in the High Court of Australia, but they have been considered in the Victorian Supreme Court in Neil and the Queen. As it was decided in a different state, it isn't binding on New South Wales either, but it can be persuasive here. Neil raised the question of whether a person can consent to a risk of infection with HIV in the course of sex. The appellant was charged with multiple rape offences because he would, at times, fail to disclose he had HIV before having sex, and then other times he would inform his sexual partners that he had the virus. The Supreme Court of Victoria said that informed consent is capable of providing a defence to a charge of recklessly endangering a person with HIV, so long as the consent is communicated to the offender. Now, this very brief review of the four cases shows us that consent will usually not be available in cases of death, grievous bodily harm, and actual bodily harm. While Neil discusses the possibility that consent could be given to an activity carrying a risk of contracting a disease, Neil is very, very different to our current case. Additionally, while Lee does seem applicable to our case due to its similar facts, The Victorian Supreme Court in Neil has said that Lee's position on the intentional infliction of injury is not to be taken in Victoria, and the court seemed to side more with the rulings in Brown. This is a difficult argument for the defense, but I'd imagine it looks something like this.
Are we having a boxing match?
Okay.
Alright, Oh, are you fighting back? Are you allowed to fight back?
Oh, am I not? Okay, okay.
I thought I was just supposed to chase you. I was just supposed to chase you. No. Like,
Okay.
I thought this was like a. Will you die?
If you punch me, yeah.
Tell me
No,
when
okay.
you're on your last heart. I don't want to kill you.
Okay.
I don't want to actually kill you.
As you can see, this is a giant fucking mess. Based on the current law, it's somewhat difficult to resolve whether or not consent would be an available defense here. If a judge determined that the law allows the court to leave the question of consent open to a jury, the prosecution would most likely fail in disproving consent. This is because the video evidence so clearly shows how Petra acted within the scope of consent. Namely, she's very cautiously punching Elira and waiting for her to tell her how many hearts she has left so Petra doesn't accidentally kill her. However, in my opinion, I don't think a judge will leave the question of consent open to the jury, because the current case law indicates strongly that consent is unavailable due to the actual bodily harm inflicted on Elira and her death from Petra's actions. As consent is unlikely to be available as a defense, Petra's acts would constitute an assault and therefore are unlawful. Without the defense of consent, Petra's punches constitute assault and therefore are an unlawful and dangerous act. But did Petra's act actually cause Elira's death? You might be thinking, you dumb fucking idiot, of course she did. But the question of causation can be more complex and technical. Usually the question of causation is simply a matter of common sense for the jury. However, if there is an intervening act or event which is a more proximate cause of the death, then the chain of causation can be broken and the accused would be found not guilty. As such, the argument Petra would try to raise is that Elira's lies were a more proximate cause of death that breaks the chain of causation. However, this chain is actually pretty difficult to break. After all, courts are not too keen on letting people get away with murder. For example, if you hold someone as a human shield in a gunfight and they get shot by the cop isn't guilty of murder, you are. If the deceased falls out of a window because of your actions that led them to behave in that way, then their death can be pinned on you. If you stab someone and the victim is put on a stretcher which is dropped twice and the doctors failed to notice the pierced lung, the courts won't say that the apparent medical negligence killed the victim. You did. If you bash someone, causing them to suffer from traumatic, life-threatening injuries to the brain, face, kidneys and chest, and then 8 months later they fall and require surgery, but they refuse due to the poor quality of life after the attack and with the knowledge that their refusal would probably result in their death, guess what? Not even that will be considered an intervening act. You'd still be found guilty of murder. As such, the rule of causation is as follows. If the act of the accused was a substantial or significant cause of death, or a sufficiently substantial cause of death, then they satisfy the question of causation. What about a person who dies from taking drugs that you supplied? That was considered in the case of Burns and the Queen, to which the court said that the supply of drugs wasn't an act that caused death, because the taking of the drugs was a voluntary decision. In this way, a voluntary and informed act of an adult negatives causal connection. The above case law makes it clear that causation can reach far and wide, and that the deceased's own actions will not sever the chain of causation if the accused's actions had an operating and substantial effect on the deceased or another's actions. For example, the accused's actions in Paget, Royale, and Swan influenced the police officer to shoot, the victim to flee, and the victim to refuse treatment respectively. I'd argue, however, that these cases are distinct from Elira's action of lying, which carried the intention to force Petra to kill her, despite Petra being very careful to only injure her as per their agreement. Elira being cheeky should be distinguished from the previously mentioned cases, which involved situations where the courts were more inclined to extend criminal liability due to their extreme circumstances involving a police shootout, extreme domestic violence, and a home invasion. Contrast this to a consensual fight between friends gone wrong, and it seems silly to apply these cases. The current case is also distinct from Aaron Smith, because in that case, the stab wound of the victim was an operating and substantial cause of death. While it was Petra's punches that fatally killed Elira, the damage each punch did was predictable and quantifiable, and as such, Petra could accurately predict when Elira was close to death. This is completely different from a stab wound, where the possibility of death is much harder to predict. As such, in the present case, Petra's act should not be considered an operating and substantial cause of Elira's death. Finally, Elira's lies constitute an intervening act that breaks the chain of causation. While Burns is specifically about drug use, it can apply to the case because both feature a voluntary decision with Elira actively causing her own death by Petra's flippers. Unburdened by the circumstances present in the other cases, Elira egged on Petra to kill her. But what about the eggshell skull rule as articulated in Aaron Blow? The eggshell skull rule is the concept that the defendant must take the victim as they find them, meaning that if the victim suffers greater harm due to a pre-existing condition, susceptibility, or belief, then the defendant remains responsible. In the present case, nothing like that arises because Elira was not more susceptible to death due to a pre-existing condition, susceptibility, or belief. Instead, she freely and voluntarily made herself more susceptible by deliberately lying to cause her own death. With regard to these rules, I think there is a good chance that a jury would find that Elira's acts break the chain of causation. In this way, there is a good chance that Petra would actually be found not guilty of unlawful and dangerous act manslaughter. Now, I was actually about to finish this script, satisfied that I've looked at everything, until I remembered Section 25A, assault causing death, exists. So, according to Section 25A of the Crimes Act 1900, a person is guilty of assault causing death if they assault another person, the assault is not excused by law, and the assault causes death. You may have noticed that Section 25A is very similar to the manslaughter rules we just talked about, and you'd be right. Section 25A is a rarely used offence, and criticised for being too similar to unlawful and dangerous act manslaughter, so then why does this law exist? Well, from 2012 to 2014, there were intense media coverage across New South Wales due to deaths caused by alcohol-fueled one-punch assaults, with the most high profile being the death of 18-year-old Thomas Kelly. His killer pled guilty to manslaughter and was sentenced to 7 years and 2 months imprisonment, with the possibility of parole after 5 years and 2 months. Now, Kelly's parents were understandably livid, and in response, the New South Wales Parliament enacted the Crimes and Other Legislation Amendment, Assault and Intoxication Act 2014. Relevantly, the amendment inserted Section 25A and Section 25B, which put a mandatory minimum sentence of 8 years if you commit an offence under Section 25A while intoxicated. As such, Section 25A is enacted to specifically target one-punch assaults, but from the plain text of the Act, there's nothing stopping the prosecution from using it to charge other types of assaults, resulting in death. And one reason why they may do this is that Section 25A can catch conduct that may not satisfy the rules of unlawful and dangerous act manslaughter. Now, this part is very important. Offences such as murder and manslaughter are common law offences codified in Section 18.1. In Section 18, the expression causing the death charged is broadly defined in case law, like Royale, Swan, etc. But in Section 25A, the expression causes the death of the other person is defined in the statute itself. Section 25A.3 modifies the word causes for the offence of assault causing death. What this essentially means is that when we look at whether Petra caused the death of Elira, we're looking at different causation rules depending on which laws you look at, and that's because statutory law trumps case law. In Arundel, District Court Judge Haisler accepted that by incorporating Section 25A.3, the legislature has evinced clear intention that the common law be displaced. The effect of this new causation clause means that a person could be not guilty of murder and manslaughter, but guilty of Section 25A. So that whole 6-minute explanation about how Petra might not be guilty because Elira's lies constituted an intervening act, none of that fucking matters under Section 25A. There's only one question we need to ask. Was Elira killed as a result of the injuries received directly from Petra's assault?
Oh shit.
Alright.
It's kind of up in the air whether Petra would be guilty of manslaughter. While it's more likely than not her acts cannot be defended by consent, it's up to the jury to determine whether Elira's lies constitute an intervening act or not. In the end though, none of it bloody matters. For the statutory offence of Section 25A of the Crimes Act, assault causing death, Petra Gurin of Nijisanji EN's Obsidian Division, Myoshi, would be found guilty for the killing of Elira Pendora.